Thank you all for coming here to the launch of the Minnesota Association of Criminal Defense Lawyers State Clemency Project. My name is Jane Ann Murray. I teach a clemency clinic here at the University of Minnesota Law School. We have a really interesting program for you tonight, and the goal of this program is to recruit and train lawyers to handle petitions before the State Pardons Board here in Minnesota, petitions for commutations of sentence and petitions for pardons. And you're going to hear tonight from people who will talk about the burdens suffered by those serving long sentences in prison, or those who carry with them a felony conviction that creates a lot of obstacles in their professional and personal choices in their lives, leading even to the potential of deportation. Our first speaker is someone who's no stranger to the State Pardon Board. It's retired Supreme Court Justice Eric Magnuson, who was himself one of the members of the Pardon Board during his period as Chief Justice of the Supreme Court. Unfortunately, he's not with us in person, but we have him on Zoom, and I am going to turn it over to him here we go.
I appreciate your efforts. And I have to apologize for not being there in person this evening. I had some surgery yesterday, and I'm still getting used to the results. But I'm very much looking forward to the program. And I want to thank Jane Ann and everyone else for giving me this opportunity. People ask me frequently, what was the hardest part about being Chief Justice? And there are lots of things that were fun, and there are lots of things that were very difficult. But one of the hardest parts of my job, frankly, was serving on the Pardon Board. Certainly the decisions are weighty and impactful, but I think it will be helpful for all of you who are considering getting involved in this effort to have a little more context. Applications for pardons are processed by staff who gather the application and comments from victims, from prosecutors, from judges, and others. They all put it in a report, including a history of prior applications. And in my experience, far too often the materials could be sparse. A lot of applications are pro se. They're not prepared with the help of a lawyer. And while they are earnest, they don't give the board a lot of the information that it needs to fully evaluate the application. And remember, it's not the job of the Pardon Board staff to make the case for the applicant. So to the extent that any positive information is lacking, it can only hurt the applicant, because when the board is in doubt, it will deny an application. You also need to keep in mind that you're asking the board to supplant the judgment of law enforcement, of prosecutors, of judges, and even the legislature that led up to the conviction and the punishment in any particular case. And that is not a step that anyone, including the Pardon Board, should take lightly. I think there's another aspect of the process that may not be well understood or appreciated. I certainly didn't understand it or appreciate it before I served on the board. The proceedings of the Pardon Board are subject to the open meeting law. As a result, there's no discussion among board members before the day of the hearing about any of the applications. There's no pre-hearing conference. There's no discussion of factors that may weigh for or against clemency in a particular case. The first insight that any member of the board has into the thoughts of fellow board members is when people start asking questions. The other thing you should keep in mind is that the decisional process is also public. Decisions have to be unanimous, so no one no vote results in a denied application. And because of all of those circumstances, the members speak their minds, but they do so very carefully. During my service, each member of the board was hesitant to force any one of the other members to be the one to say no, to stand alone on an island. And so the discussion was at times elliptical and more nuanced than I would have liked. But remember, even one no vote satisfies no one. The applicant is denied a chance they hope for. And by the same token, the victim or the judge or the prosecutor may feel that their views have been undervalued in some way. All of that affirms the importance to me of the applicant making a strong and compelling case from the outset. Remember, this is not an appeal. Guilt is given, and a request for clemency without acknowledging responsibility is really unlikely to succeed. Excuses are generally not persuasive. Having said that, what is clear is that if the circumstances are properly presented, they can have a significant impact. I'll give you an example of one case that has stuck with me over the years. A young single mother on welfare failed to report income she had earned on a side job. She was charged with felony welfare fraud. And while it was clear she needed the money to feed and clothe her children, it was also clear that she knew what she was doing and she knew that it was wrong. But despite her guilt, those extenuating circumstances were there. Now, she didn't deny her culpability. She didn't say, I needed to take the money and you should excuse me. She said what I did was wrong. And she let the circumstances of her life speak for themselves. What she did show us at the pardon board was that she'd repaid all of the money. She had really worked double time to do that. She had raised her children successfully. She had become a contributing member of the community going forward. And more importantly, she had reached out to help others who were struggling with the same circumstances that she had found herself in. That was a compelling presentation. And not everyone can make such a rags to riches story, but it was successful in her case. And we didn't give out a lot of pardons when I served on the board, but she received one, which is all kind of a long way of saying that presenting a full picture for the applicant is absolutely essential. You don't want to just show there are no further transgressions, but you need to show that there's true rehabilitation, recognition of the wrongfulness of the conduct, but also taking responsibility for it. And if you can, show that that the applicant has acted affirmatively to help others, for example, avoid the same mistakes. This is a very long way of saying that a carefully prepared application is absolutely essential, and a strong case that emphasizes change, growth, and responsibility is needed to carry the day. Applicants need all the help they can get in sharing the narrative of their journey. They are not trained for this. They don't understand completely how the process works. You as lawyers can help them with that, and you can be far more effective than someone proceeding without your help. So in the end, if you volunteer, you can make a difference. It is extremely difficult to get a pardon or a commutation from the pardon board, but it can be done. It can be done in the right case and can be done in the right way. And we need, when I say we, I mean the people involved in this project, and frankly, I'll speak for the pardon board itself. They need all the help they can get. It's not an adversarial process. It is a journey together, and I hope that you can join them in that process. Thank you, Jane Ann.
Thank you so much, Judge Magnuson. And I should also add that Judge Magnuson is the chair of the steering committee for the MacDill State Clemency Project, and he's been an incredible resource in helping us plan our process and our plan to recruit and train volunteers, assign them advisory council to help them through it. And we also have several members of that steering committee here tonight, and I know I'm not going to catch you all, but I see Bradley Colbert and James Fleming and Catherine Middlebrook. And there's perhaps others that I'm missing at the moment. I'm now going to turn it over to our main speaker tonight, who is Carl Procaccini. He is the General Counsel to Governor Walz and has worked very closely over the last several years on the pardon process from the governor's perspective. He's got just as we got that great inside view from Judge Magnuson, Carl Procaccini has a very detailed knowledge of the process and the system, and he's going to lay this out with a PowerPoint, which my wonderful tech assistant is going to bring that up for us now. Thank you.
All right. Well, thank you, Professor Murray. Thank you, everybody, for being here. A lot of familiar faces in the crowd. Really appreciate the interest in this project. It's critical, and it's going to improve lives in Minnesota. So thank you all for being here. So I'm going to give an overview. So I'm going to give a quick background and context around pardons in Minnesota, talk about some recent developments, walk everybody through the basic process for applying for relief from the Board of Pardons and the governor, and then talk through some best practices for lawyers who are representing folks in front of the board. Okay, so to get started, just to level set a little bit, and you just heard from a former Chief Justice, and our Constitution sets up a joint power between the governor and a Board of Pardons to grant clemency in Minnesota. And although the Chief Justice sits on the Board of Pardons, the Supreme Court has explained this isn't a judicial process. This is the exercise of the sovereign's prerogative of mercy, the executive's prerogative of mercy. And it's an act of forgiveness and redemption. It's not a judicial proceeding, and you're not going to court when you represent a client in front of the board. And so important to keep that context in mind as you're representing a client throughout the process. So going to the Minnesota Constitution, this is the pardons provision in the Minnesota Constitution, and it's pretty unique in that it does create this Board of Pardons that includes two members of the executive branch, the governor and the attorney general, and the Chief Justice of the Supreme Court. And this Constitution says that the governor, in conjunction with the Board of Pardons, has power to grant reprieves and pardons after conviction for an offense against the state, except in the case of impeachment. And for the 120 or so years or more that this language was part of the Constitution, the Supreme Court of Minnesota hadn't had an opportunity to interpret that language. Earlier this year, we actually did get an opportunity to know a little bit more about what that language means. And the Supreme Court described it as the governor and the Board of Pardons each holding a key, and both the board and the governor have to turn that key in order to grant a pardon. And we'll talk a little bit more about what that means currently, but the Supreme Court made clear that with respect to the board, the legislature can set the board's powers, and currently the legislature has elected to require a unanimous vote of the board in order for the board to turn its key. So right now you need a unanimous vote of the board, which includes the governor, in order to grant certain forms of relief in front of the Board of Pardons. The statute also provides that the board secretary is the Commissioner of Corrections, and Chief Justice Magnuson addressed that a little bit. The Department of Corrections prepares briefing materials for each of the board members before the board hearings. It provides application forms to applicants and receives and screens all those applications and runs the meetings. And we'll get into that a little bit more. There are four types of clemency envisioned in the Constitution and in statute. The first and the most common is the pardon extraordinary, which is sort of a unique creation of Minnesota law. This is relief that is available to folks who have completed their sentences, and it has the effect of setting aside and nullifying their conviction, and recipients of a pardon extraordinary are not required to disclose their conviction other than in a judicial proceeding or in the licensing process to become a peace officer. There's also the more traditional pardon that you probably think of when you hear of a pardon. These go to folks who are currently serving their sentence. And of course, pardon, if somebody receives a pardon, it sets aside and nullifies their conviction. It ends their sentence. It's as though the conviction never happened. And statute sets out that a pardon can be absolute with no conditions or conditional. And so the board can set certain conditions for someone to satisfy and maintain in order for the pardon to be in effect. The board can also grant commutations, and this is a substitution of a lesser sentence. And in recent years, we've seen both commutations to shorter duration or a different sort of sentence, moving somebody to supervised release sooner than they'd otherwise be eligible. This doesn't set aside or nullify the conviction, it just modifies the sentence. And the constitutional language that I just read includes the word reprieve, and statute also provides that the board has authority to grant reprieves. We haven't seen a reprieve in modern history. We do have one application that the board will be hearing later this year, and we maybe have an opportunity to take a look at a reprieve for the first time in a long time. And that's undefined in statute. Generally speaking, when states do reprieves, it's a delay of the execution of the sentence. You most commonly see it in a capital punishment case. Of course, we don't have capital punishment under Minnesota state law, so reprieve sort of fell into disuse in the past century. So just quick, the reasons that folks might seek a pardon or commutation are probably pretty obvious to this audience, right? If you're serving a sentence and you get a pardon, you're out. If you get a commutation, we're shortening your sentence. The incentives there are pretty obvious. We sometimes get the question, why would somebody want to get this pardon extraordinary? They're done with their sentence, and as we'll discuss, they've also waited out a waiting period to apply. Why would you want to do this? We get a lot of folks who are really interested in getting the pardon because they're being prevented from pursuing employment opportunities because of the conviction on their record. A lot of folks are excluded from volunteer opportunities, coaching their kids, football team or baseball team that require that clean background check. We've been seeing more and more folks who have immigration-related pardon applications. A full pardon from the board can be a way to prevent removal under the federal removal statute. A lot of folks are interested in restoring their firearm rights, and I think most importantly for a lot of people, it's that notion of closure and redemption. That they've served a sentence, they've completed it. And they've proven all those things that Justice Magnuson was discussing, and have become members of society, and they want to remove that stain of the criminal conviction from their record. Some of the limitations on clemency in Minnesota. The Constitution makes clear that clemency can only be granted to somebody who's been convicted of a crime. And so this is actually a little bit different than the federal pardon power, and maybe the most famous pardon, the pardon of Nixon. Nixon hadn't been convicted of anything, and so, but yet he was the beneficiary of a federal pardon. And in recent years, we've heard some discussion about the former president was maybe interested in issuing some pardons to folks who hadn't yet been convicted of things. That's not an option under our constitutional regime. The pardon is only available to folks who have been convicted in Minnesota State Court. The relief is limited to Minnesota state convictions. We can't grant relief for convictions in other states, federal, tribal, or non-criminal enforcement actions. And so those are some of the limits on what is otherwise a really good form of relief to pursue. So to give you a sense of some recent developments, I think it's actually been a really exciting 4 years for the governor and the Board of Pardons. And in some ways, the Board of Pardons had gotten out of the business of granting forms of relief beyond that pardon extraordinary, which is the post-sentence form of relief. And so we've seen an uptick in the board's willingness to grant other forms of relief. And in particular, in June of 2020, the board granted its first commutation in 28 years. There was a second commutation granted just 6 months later. And then in January of 2021, we saw the first full pardon, somebody who was serving a sentence in over 35 years. And then the third and fourth commutations quickly followed in December and June of December of 21 and June of 2022. Happy to discuss more the reasons for that, but I think this is a reason for folks in this room to feel like you've got a board and a governor that are interested in granting this relief when it's due, and using the full range of authority that the Constitution grants to the governor and the board. So just to give you a quick sense of trends that we've seen, and basically the equation here is we've had increasing applications and increasing grant rates, which have led to a pretty marked increase in the total number of applications granted over the past couple of years. I'll say this, when the governor was elected the first time in 2018 and 2019 early on, the First Lady said that she was hoping to flood the zone with pardon applications, and we've seen that over time. We've seen a real increase in pardon applications, as this graph shows, an average of about 67 applications heard in the decade sort of preceding the current administration, and we were up to 151 in 2021, and I think the data in 2022 is going to show that we had an even bigger increase this year. And so with increasing applications, we've also seen an increasing grant rate by the board. So again, in that sort of decade preceding the current administration and the current makeup of the board, we had about a 39% grant rate for pardons extraordinary. Again, that was the only category of pardons that were being entertained for the most part in those years. And in 2020, we got to 74%. 2021, we were at 71%. And this year, we're halfway through the year. We have another meeting in December. We're again above that mark, around 72%. So we have seen a pretty substantial, statistically significant increase in just the sheer number of pardons, or the percentage of pardons granted, which leads us to something that we should all feel good about, which is a real increase in the total amount of relief granted in the past couple of years. So again, an average of about 14 applications granted in the previous decade, up to 29 in 2020 and 41 last year. And I think we're on pace to meet or beat that number here in 2022. So to talk through the basics of the process here, interestingly enough, there isn't a lot of statute on some of those core forms of relief. So pardons, commutations, and reprieves, you essentially have to satisfy those constitutional requirements. You have to committed a crime in Minnesota and be serving a sentence if you're looking for a pardon or commutation. The pardon extraordinary, because it's a creation of statute, and the legislature has taken some time to provide some requirements there. Again, you have to have served and discharged your sentence, and you have to have completed a statutory waiting period. And the waiting period is shorter for nonviolent offenses, longer for violent offenses, and violent offenses, by the way, does include felony drug offenses. Applicants can request a waiver of the waiting period, but that requires, under statute, a unanimous vote of the board. And you can't have any criminal convictions during that waiting period. Essentially, if you do commit another crime in the waiting period, it resets the waiting period. So here's the basic timeline and procedures for how an application makes its way to the board. There are 2 application deadlines every year. It's December 1st for the spring meeting, which is generally held in June, and then June 1st for the fall-winter meeting, which is generally held in December. Once an application is submitted, the Department of Corrections does a thorough screening, much of which is set out in statute. There's a thorough background check that includes a background check here in Minnesota and in other states. And corrections is required to contact the original judge, sentencing judge, the prosecutor, and the victim, if there is one. And so this is an area where I think I differ a little bit from Justice Magnuson in his characterization of supplanting the judgment of the prosecutor or the judge, because many of the cases that we have, we get support from either the prosecutor or the judge or both, recognizing that some circumstance has changed and they're actually supportive of the relief that the applicant is seeking, particularly for the pardons extraordinary, where we have people who are 5 or 10 years out from their sentence and a long ways from their initial conviction. So in those cases, I think frankly, that's important persuasive evidence for the board if the sentencing judge or the prosecutor are supportive of the application. Even more persuasive is a positive, supportive statement from the victim themselves, and it can be really critical, particularly in the case of somebody who's committed a violent crime. So the meetings occur in June and December. We're getting so many applications that they're now, we're going to have 2 full days of hearings this December, and so we're going to have a full day of pardons extraordinary, and then it looks like another full day of pardons and commutations. At the hearing, the substantive petitions for relief are heard, and the applicants are heard. The board does hear a couple of petitions on the papers. Those are the waivers of the waiting period, and then petitions for rehearing. There's a public vote, but they're voted on the papers, and there's not a hearing. The current voting requirements, which are set forth in statute, is that a unanimous vote is required for the pardon, commutation, pardon extraordinary, and waiver of the waiting period. Missing from that list is the reprieve. Statute is actually pretty clearly does not include a reprieve in the list of relief that requires a unanimous vote. And somebody who's been denied a petition in the past and wants to have their case reheard needs 2 votes in order to be reheard by the board. I'm not going to go through the next 2 slides in detail, but I think we could probably make these available to folks if you're interested. But we just have some flow charts of the basic sort of decision tree for a pardon extraordinary and for the pardon and commutation. The one thing I want to highlight here is that for the pardon and commutation process, there is a procedure that's set forth in board rule, which the provenance of the board's rules is something that is lost to Minnesota history, as far as I can tell. They're quite old, but they do set forth a screening process where the Department of Corrections takes a first cut at all of the applications for pardons and commutations, and based on criteria that are set forth in rule, they determine whether or not an application should be placed on the agenda for the next board meeting, or whether it should be excluded. And the board members receive a report of all the excluded application, an explanation of why those applications have been excluded. And if any one board member wants to hear that application, despite the assessment of corrections that the application should be excluded, they can ask that application be added to the next board meeting. So if somebody applied for this most recent meeting that's coming up in December, and their application was excluded, and a board member wanted to hear that application, they'd be put on the agenda for the June 2023 meeting. All the application forms are available on the Department of Corrections website. We're always taking a look at those and trying to improve them, and I certainly welcome feedback from folks, practitioners who see issues with those forms. We've recently added an application for rehearing. That used to be a kind of more informal process, but now we have a formal application for that. And so you've worked with your client they've submitted an application. It hasn't been excluded, or it's an application for pardon extraordinary, which means that they will get a hearing. Again, these are public meetings. It's an unmediated discussion between the governor, the attorney general, the chief justice, and the applicant, which is kind of a wild experience. If you haven't been to a meeting, I highly recommend it. It's worth seeing, especially if you're going to be representing clients who are appearing before the board. Applicants briefly address the board. They can bring folks who want to testify on their behalf. Victims are invited to attend. They can provide feedback either in writing or show up at the meeting and testify. And critical to this group, some have attorneys, most do not, and it would be nice to reverse that. And then the board members ask questions of the applicants and of their attorneys, often the questions are about the offense itself, rehabilitation efforts, and they're often interested in sort of the criminal history, criminal record, and non-criminal record petty misdemeanors that folks may have since their conviction. Is that my time up?
No,
Okay. All right, so quick, just onto the best practices, because I'm thrilled to see all of you here, and I think the board would be thrilled to see all of you in front of them. If you're law students, I mean, what a kind of a wild opportunity to appear before the Chief Justice of the Supreme Court, the Governor, and the AG, and argue a case. It's pretty cool. That said, I do have some thoughts on not taking too much out of that experience. And I'll tell you what I mean. So just generally in the application process, we want folks to be as thorough as possible. And that means erring on the side of including as much of the background as you can possibly find. And that includes petty misdemeanors, convictions in other states, significant civil proceedings. I will say that corrections does a first cut on somebody's background. Each of the board members have staff that are going to dig into people's background, and so it is highly unlikely if there's something in your client's past that one of those three board members isn't going to find it and potentially bring it up if it's not in their application. So you want to, I think, err on the side of over-disclosure in that application. You want to convey all the facts accurately. We'll have folks looking at the court transcripts and so forth, so if a case is described one way or, characterized, we will likely learn that in the process of the vetting. It's important to include that evidence of rehabilitation, including evidence of community and victim support, like I said earlier, is really critical. And one thing that I just recently added to the slide, because it's really become a thing in the past couple board meetings, is ensuring that if there was a restitution component of the sentence, and it's been paid off, that we have evidence that it's been paid off, because sometimes the court records can be kind of all over the map on this, and so if your client has good proof that the restitution was paid, just throw it into the application, give us a copy so that doesn't become an issue at a hearing. We've actually had a number of applications sort of continued just so the applicant could go and find that evidence that restitution had been paid. Two big don'ts. And there's an asterisk next to the first one, and I would just say, generally speaking, unless you've got a really, really clear case of innocence, which, of course, there are other judicial remedies if you do, I highly advise against just sort of throwing that in the laundry list of reasons why your applicant should get a pardon. I think, like going back to my first slide, this isn't a judicial proceeding. There isn't the board does not have the sort of mechanisms to weigh evidence or to relitigate a case on the merits. And frankly, the claim of innocence sort of cuts against, I think, what the board is often looking for, which is acceptance of responsibility, remorse, and rehabilitation. So there is that caveat that if you've got that rare case of actual innocence, I don't want to dissuade people from taking it, but I wouldn't make that move lightly, and I'd want to really make sure you had a strong case there. And then the other thing, and this should be obvious to this audience, but blaming the victim, the system, the judge, or the prosecutor doesn't get people very far in this process. Again, I think oftentimes the board is more interested in hearing about acceptance of responsibility, and also, and even more than that, just all the great things that somebody might be doing, whether they're incarcerated or post-sentence, you know, to be great community members, and why they should get that sort of redemption. Quick for council. This is why I'm saying I think it's a great opportunity for folks to get up and be in front of this panel. At the same time, I think sometimes council can make a mistake if they spend too much time talking and not allow their client the opportunity to really tell their story. And I think that the most important thing that a lawyer can do is practice with their client what their client's going to say to this board. Your client's going to get 5 to 10 minutes to talk to the Chief Justice, the Governor, and the AG, and they can make or break their case with heartfelt communication directly to them. And the board members want to hear directly from your clients. And so my recommendation for council is to briefly introduce the client, raise any unique or important legal issues that may arise, particularly like if there's an immigration consequence, something along those lines. We want to know about that. But then step aside and let your client speak for themselves. Consider those additional witnesses. You don't need to bring 10 witnesses, but consider the 1 or 2 who could really speak to the quality and character of your client. So don't monopolize the time, and don't get into legal arguments relitigating the case, because that's just it just doesn't work in the time frame and in the composition of the board. And then for the applicants, I think that 5 to 7 mark, you practice with your client to get them to be able to tell their story in that amount of time, that acceptance of responsibility, acknowledge harm to the victim if there is one, talk about rehabilitation, and be honest. You know, like these cases, you know, sometimes the facts are tough, and being able to face it head on rather than minimizing it is the way to go. Again, there are board members who will have read that sentencing transcript and they'll know what the crime was. So minimizing the crime, I think, if anything, backfires for most folks. And it's the same don'ts for applicants as that we have in the application section. Don't argue innocence unless you've really got it. And then the final thing I'll note is just the humor falls flat in this context. The board is hearing really serious applications about really serious crimes, and it almost never works to start your presentation with a joke. I'll wrap it up there. I'll say that we've listed out some resources. The one thing I'd say on the criminal records is don't just rely on a simple MNCIS search. Get your client's full background check. From BCA, if they've lived elsewhere, try to get their background check from other states, because we will have that, and that will help you with the application. So with that, I will turn it back to you, Professor.
Thanks so much, Carl, for that really interesting and comprehensive survey of the clemency process. And as Carl pointed out, things are certainly beginning to look up, that there have been commutations in the last several years after a long period of none. But it's still a big uphill battle, and it's a lot of work to maybe end up getting a denial. However, there are other second look mechanisms in the works, bills pending in the legislature to allow a judicial second look, a potential rule change, and conviction review units, including excessive sentencing review units being developed in prosecutors' offices. One of them is in Ramsey County under John Choi, a very interesting program, and we have the head of that program, Michelle Montero, who's going to come in and talk to us now briefly to give us a little background on that. And the idea is that, our volunteers can write up a clemency petition, which is a very comprehensive document, submit it for clemency, but if that doesn't work, there will be these other ways in which that petition could be reworked and used in another context. Thanks, Michelle. Do you want to step up here? Or it's your choice. If you'd like to just stay. Yeah, okay, thank you.
Hello, so I am an assistant Ramsey County attorney, and I'm working on sentencing review primarily. I was initially hired to do conviction review. Shortly after then, the Attorney General's office opened their conviction review unit, so I started focusing mostly on sentencing review here. And we kind of wanted to pursue a judicial proceeding because, as was presented, that so much time went by with no commutation. So at that point, it wasn't really seen as a, ability to get people resentenced or get people's sentences commuted. So what we're working on is what's called prosecutor-initiated sentence adjustments. And this is kind of a movement that's kind of spreading across the country. The first prosecutor-initiated sentencing adjustment was passed in California in 2018, Assembly Bill 2942. And since then, it's kind of picked up. A bill was passed, a legislation was passed in Washington State, then Illinois, then Oregon. And we're hoping we can get a bill passed here in Minnesota as well. In August, the American Bar Association passed a resolution recommending that all courts have a mechanism for a second look resentencing. And also a draft of the Model Penal Code also made this recommendation. So it is picking up steam across the country. So in Minnesota, we've got incarcerated individuals whose sentences, should probably at this point be reconsidered. Now, they might be recognized as being unfairly harsh. They no longer might serve the interests of justice, and the individual that's incarcerated might not any longer pose a risk to public safety. I spent a lot of time looking at Minnesota and also specifically Ramsey County's prison population, and we have a pretty large aging population in the state of Minnesota incarcerated. In 2021, when I looked at the statistics, there was 183 individuals that were over 64 years of age, and there were actually 10 individuals incarcerated that were over 80. There was a large population of people that committed their crimes as juveniles. There were 10 individuals that committed their crimes at age 13 or under and had been incarcerated for 10 years or more. Also, individuals serving lengthy sentences for drug offenses. Some people were incarcerated under old drug sentencing statutes that changed in 2016, as most of you know. 58 people with drug offenses were incarcerated that had served more than 7 years. And these are statewide numbers. These are not just Ramsey County numbers. We also see stark racial disparities in Minnesota in the incarceration population. 7% of Minnesotans identify as African American, yet the Minnesota prison population is 37.12% identified African American. 1.4% of Minnesotans identify as Native American, yet their prison population is 8.71%. So what we're hoping is some of these disparities can be remedied with sentencing review. In Minnesota right now, we don't have a legal avenue to initiate prosecutor-initiated sentencing adjustments through the courts. There are two options that we're working on, with the best option being legislation and the second best option being a rule change. There is a bill that was sponsored in 2021, House File 901, for prosecutor-initiated sentencing adjustments. It was modeled on the California bill that was passed in 2018 that I previously mentioned. It passed the House of Representatives Committee. I think it was a bipartisan support, but I don't swear to that. But then it was not taken up by the Senate. Now, recent election represents a new opportunity for this legislation. So we're hoping that it will be brought back up and hopefully pass. So the second best option is an amendment to the Minnesota Rules of Criminal Procedure, 2703 Subdivision 9. We've had a Ramsey County work group that's worked on this for about the last year, trying to come up with a rule change. Some of the people on our group are in this room here today. So that would be our second best option. We're hoping legislation will go through now that we've had a change in the state Senate. So eventually what we're hoping to do is get a mechanism that we can have prosecutor-initiated sentencing adjustments in Minnesota. In Ramsey County, then, our plan would be to actually have a sentencing review unit. Several jurisdictions across the country have these units. Most of them operate under this legislation that's been passed, where they have a unit that actually reconsiders and relooks at people's sentences, people that have been serving long sentences. These are not people that are claiming innocence. These are people that have been incarcerated, most of them for a long time, and deserve a second look at their sentence. We envision this to be a non-adversarial process. We've been working with an organization out of California called For the People, they're a great organization. They help with the legislation in California, but then they also help with reaching out and working with inmates to, come up with a package to present to the sentencing unit as to why they should be resentenced. So we have been working with them and would continue working with them if we're able to get a mechanism to do this. We would plan on probably some proactive reviews where we look at the prison population, identify individuals that, may not need to be incarcerated anymore, and then reach out to them, work with them to see if they would be appropriate for sentence adjustments. Also, we would envision taking individual applicants. Anybody could apply and ask for reconsideration. And secondly, I guess finally, very important to address, victims' concerns in this process. There's an organization called Healing Justice that we've worked with and would continue to work with to comply with the Victims' Rights Act, but also get input from victims, meaningful input, and address concerns that they might have. There are a lot of resources in this area, and if anybody's interested in it, I'm happy to provide that to you. So that's where we're at, and thanks.
Thanks so much, Michelle. That's really a fascinating project that's happening over there, and hopefully one that will be replicated throughout the state. I don't believe we have Eliza in the audience. At this point, I'm just going to say that if you're interested in volunteering in this program, we're in the very early stages, but please reach out to me and we will get back to you with a case. And we have, as I say, a steering committee that is going to help us find those cases that we think would be very clemency worthy and have potential of getting clemency from this board. And we will also have advisory attorneys work with you to help you complete that process as well as possible. I want to thank again our sponsors who I didn't, where I muffed that a little earlier. So a special thanks to Ike Messmore from Nelson Mullins and to Eric Newmark from Newmark Storms and Dworak for their very generous sponsorship of the reception, which is awaiting us upstairs. I also want to thank Randall Barrett, our technician this evening, who was really terrific helping set up all of this for us. I want to thank my students, Julia Casbohm and Victor Jimenez, who helped with registration and setup as well. Special thanks to Shauna Kiefer, who's the head of the CLE for MACTL, who really helped helped us organize this and is helping get you your one CLE credit for this program. I want to thank the University of Minnesota Law School for hosting the event. We have a few minutes before we retire upstairs. Are there questions people would like to present to Carl or to Michelle? Brad?
I have a question. Is there possible to get the information that the DOC prepared? Because I feel like that would be nice to have.
Yes, I believe it's all public data.
The memo that they're going to give to the Chief Justice and the Governor.
Yes, and I believe it. I believe they. I think that they posted on their website in advance of the meeting, and so if you're having trouble accessing that, yeah, we could talk more. Yeah, it's public data.
They do post that long memo, but my experience was that it came maybe a few days before the hearing, so it's not really sufficient time to be able to respond to some of the things that are contained therein. And then, of course, those disappear once the meeting's over. All those documents disappear, Brad, so I don't know where you would get them again. Yes, we have a question up here from Ike. Hi.
Presentation. When the original judge and prosecutor and victim, if they're around, are asked to weigh in, do they get to see the written application first, or are they asked to kind of draw on their files and recollections?
I believe they're provided with the application. Yeah, that's my understanding, and they essentially get a form where they can write their feedback in, or express their interest in talking with somebody at correction.
And the application is also posted on the website a few days before the hearing, so if they don't see it first, they'll see it at that point. Bruce?
I have a question for Carl. I just wondered if you are able to comment at all on Myron Burrell's commutation, because I would think it violated all the rules. There was a criminal claim of innocence and certainly blame to the judge, prosecutor, and the system of justice. And I just wondered how that was dealt with.
Yeah, it's a great question, because you're right, but one of these, so a couple of things about that case that made it unique. One was that there had been, in anticipation of that hearing, a pretty extensive review by an outside group led by Professor Osler and others, who I'm going to forget, but the Innocence Project and others. So there's a very extensive record from this independent group looking at it, and they sort of reached two conclusions though. One was that there was some ambivalence around the question of guilt or innocence, but there was a resounding agreement that the sentencing had been too harsh, and given his age and the circumstances, and so and that part of the report was joined by the prosecuting office. I can't remember what the judge said now. In retrospect, I probably should remember. I don't know. I have former members of my team. I don't know if they remember exactly what was said, but. And so when the board took it up, it was the application was asking for a pardon or a commutation. The board took out the commutation part of it, and so it wasn't a full pardon absolving him of guilt, but it was a recognition that the sentencing was too harsh, and given all the circumstances, and so I believe his sentence was reduced down to 20 years, which made him immediately eligible for supervised release, and so that day he was put on supervised release, and I think his supervised release should be coming up relatively soon to be completed. So the commutation, that's actually an interesting point. I think if it had just been a pardon based on actual innocence, I'm not sure it would have gone the way it would. There was another interesting circumstance of that case, which is that the Chief Justice was actually recused, and so it was a unanimous vote of the board duly convened, which was 2 members, the governor and the attorney general. And I'll leave it at that.
Yes, thank you.
Given that with our pardons and commutations, there's often a great deal of time that has passed since there was a trial, I'm wondering how aggressively they look. What about the judge that's no longer sitting on the bench but maybe still alive, prosecutor no longer a prosecutor? I've certainly encountered witness families that just don't exist anymore. What do you do in those circumstances, particularly with the judge and the prosecutor?
So we're trying harder, is what I'd say, but I would also say there's limited capacity, as is often the case in government. We just don't have unlimited resources to track everybody down. But we are pushing a little bit to try to get in touch. If we know that the judge is a retired judge, we're using a little more shoe leather to get in touch with them. It's often the case that we have cases going back 30, 40 years, so like contacting the victims is nearly impossible. So corrections does what it can, but if they can't, that happens from time to time. The prosecution office, that's an interesting one, because actually I think generally speaking, we reach out to the Ramsey County Attorney's Office, so it's the current county attorney who sort of gets to weigh in, regardless of whether it was John Choi or somebody 30, 40 years ago. So that's an interesting question that I honestly haven't given a lot of thought to, but is an interesting one.
I have one coming up where this prosecutor in disgrace. So I'm wondering what's going to happen.
Well, hopefully it will be the current county attorney who would be able to.
I want them disgraced.
Oh, you want the disgrace? Okay.
Okay.
Right.
Fair enough.
Yeah, I have to say I've done a lot of federal clemency cases where I've found afterwards that prosecutors who've been hauled up on disciplinary or, disgraced in some opinion, a lot of defense counsel who are disbarred. And so I sometimes raise an ineffective issue, and we do always try to reach out to the sentencing judge if we think there's a potential to get a favorable letter, so that we do the shoe leather for them, on that issue. Question, Satfir, yeah.
How long is the average hearing? Are there any rules of conduct like there are rules of court to follow?
That's a great question. So we budget about 15 minutes per pardon extraordinary, a little bit longer for the pardons and commutations. So it goes by quickly. So I would say again that we generally try to ask folks to limit their presentation to about 10 minutes, about 5 minutes of questions, and then there's a vote. So there's a lot of prep work that goes into it, but the hearing itself is very quick. No rules of decorum. Mark Osler, I would describe one of the many reasons why we have a higher grant rate in the past few years is that Professor Osler has volunteered his time to do a quick prep session to go through some of these best practices and some others with applicants. And so if you do represent an applicant, highly recommend you tune in to watch his presentation. He usually does it a week or two before the hearing. No specific rules of decorum, but I think it's probably the same advice you'd give to your clients going into court. You want to be dressed in a presentable way. You want to be respectful in how you address the members of the board, and just some of that other stuff like practicing and not taking the crime seriously, practicing not making jokes, those sorts of things. But no specific rules of procedure or decorum.
So is it in the prep that you really see the role of attorney, because it's only 15 minutes and you want the applicant to do the talking?
Yeah, I think we're looking for like your best 2 minutes as an attorney at the hearing, and you're critical to the preparation of the application and the preparation of the applicant before they appear. The application, you're making sure that you've helped them figure out all their background and do they have $50 of outstanding restitution, and can they get that paid before the hearing? You're working with them on that, and then you're there to be that sounding board and have them practice with you, because that makes a huge difference. And then of course you're there in case there are questions that come up about the record or about something that happened at the trial, something like that. But I do think your job is to do all that prep work in advance so your client really shines at the hearing when they're talking to the board.
And I just want to give a shout out to Professor Osler too. He was on our original lineup when we were going to do this program last month. Unfortunately, he's out of town today, but he is obviously the leading kind of scholar and knowledgeable person about clemency in this state, and has done enormous work in helping individuals do the most effective presentations they can. Unless there's a burning question, we're at 7:05, and so I would suggest that we retire to the Auerbach Commons upstairs. You're all invited to the reception, and I want to especially thank our wonderful speakers, Judge Magnuson, Carl Procaccini, and Michelle Montero. Thank you all so much.